And joining us now is ABC News legal contributor James Sample. James, always good to have you with us. California's redistricting was different in that it was the voters, not state legislators, who ultimately made the call. Might that affect how judges ultimately rule on California's new map?
You're right that that's how it came about, Lindsay. And in theory, it shouldn't matter at all. In practice, it might. Just 6 years ago in a decision called Rucho v. Common Cause, the court effectively rolled out a red carpet for partisan redistricting. The idea that federal courts cannot review even the most partisan, most skewed, most undemocratic maps if those maps are pursued for purely partisan ends. Ironically, perhaps, the most favorable fact for what California did in terms of California having that be upheld subsequently in the courts is that it was a nakedly partisan in purpose redistricting. It was responsive to what Texas had done. Their purposes were purely partisan. And although that makes absolutely no sense to most people on a common sense level, it's frankly crazy and undemocratic. It is a product of the Supreme Court's decision, and that might actually redound to California's benefit.
All right, so you mentioned the Supreme Court. So explain something here, because the Supreme Court ruled in 2019 that partisan gerrymandering is a political issue that federal courts have no business in determining, yet it was a panel of federal judges who just blocked Texas's new congressional map. So how did that happen?
Good question. The backbone of today's decision is a distinction that exists in the law. Basically, the one area in which redistricting is still subject to review by the federal courts is the area that was at issue today. So the court has drawn a line over the last several years that says that purely partisan gerrymandering is beyond federal court review. But gerrymandering that is designed around racial purposes, racial gerrymandering, is still subject to the court's scrutiny. And what the court in Texas found today by that 2-to-1 margin that you mentioned is that rather than pursuing this purely on a partisan basis, the redistricting was designed around racial purposes and in fact relied heavily on a letter from the Department of Justice that was all about race and did not mention partisanship one time. So in a sense, this is the inverse of the California circumstance, and this is the one area where the Supreme Court still polices redistricting. It is still unconstitutional to redistrict in a manner that dilutes or is intended to discriminate on the basis of race.
Thanks so much for that explanation. Makes a lot of sense. So, James, Texas AG Ken Paxton said that he would appeal the state's case to the Supreme Court. Will he have a solid case?
He will certainly have a receptive audience. Let's say that. Donald Trump is on a winning streak in the Supreme Court, and the Supreme Court justices are not blind to what's happening in the world. This was frankly an own goal, if you will, by the political operatives in the state of Texas who should have known better, who should have known that if they, instead of casting their purposes in racial terms, they could have accomplished the exact same end, characterizing them in partisan terms. In the Supreme Court, you may find that the court majority may recharacterize what happened based on their understanding of the real world consequences, that this is something Donald Trump asked for, that it was in many respects intended to be partisan, even though it was blundered to that extent. And if so, the court may effectively save the Republican Party of Texas from itself.
James Sample, always appreciate your legal analysis and insight. Thanks so much.